Hi, my name is Rafael Lázaro. I am the owner of Lázaro Law Group, an employment law firm based in Chicago, Illinois. In this video, I want to talk to you about non-competition clauses. You know, in certain sectors of the economy is turning around, and we've been getting a lot of questions about non-competition clauses before the employees get hired. So how do you negotiate a non-competition clause so that it doesn't come back to bite you after you terminate your employment with that employer? In this video, I'm going to provide you 4 tips to effectively negotiate a non-competition clause. Tip number 1, know and learn what the why is. Why is it that your employer wants you to sign a non-competition clause? In many occasions, once you learn the why, you can effectively convince your employer not to enter into a non-competition clause. And that is because the non-competition clause is not going to necessarily solve the issue that the employer is concerned about. For example, if the employer is concerned about trade secrets, you should enter into a non-disclosure agreement, not necessarily a non-competition clause that is going to restrict your ability to find a job later on. If your employer is worried about you taking with you some clients, that is a non-solicitation clause, not necessarily a non-competition clause. So the first tip is learn the why and use that as a springboard to negotiate a substitution for a non-competition clause. Tip number 2, if your employer insists on you signing a non-competition clause, your job is to ensure that you limit it as much as possible. What I always try to do and what I always try to push for is limit the non-competition clause to those entities and persons that the employee had direct contact while employed at that particular employer. If you cannot do that because the employer won't sign off on that, then you limit 2 things. First, geography. Where exactly the non-competition clause is going to apply. You want it to be as restricted as possible. 5-10 miles would be fine. And the other thing that you can negotiate is time. How long after your employment ends will that non-competition clause be effective for? So that's tip number 2. You should limit and limit the non-competition clause as much as possible. Tip number 3, if you're signing off, especially if you've already been terminated and you're signing off on a non-competition clause that is worth money, that is valuable, you should be compensated for restraining your ability to go to the competition. Especially in those situations where you have been terminated, you should try to be compensated appropriately for signing off on your rights to find another job later on. So that's tip number 3. And tip number 4, find legal counsel. Non-competition clauses are not enforceable in every state. In California, North Dakota, those compensation clauses are not even enforceable at all. And here in Illinois, they are enforceable only for high-paying jobs. Low-earn workers, you cannot restrict their ability to find another job. There is a specific law in terms of that. So a lawyer is going to be able to negotiate more effectively for you. He's going to know the law. So if the non-competition clause is too aggressive, he'll be able to limit those for you. 1 or 2 hours of a lawyer today is much better than being hauled into court later on. So I would highly suggest that you find a lawyer. Those are my 4 tips in terms of non-competition clauses. I hope you enjoyed this video. I certainly enjoyed making it. So see you soon, everybody. Take care. Bye-bye.